So, one of the last cases we're going to do in the abortion rights section doesn't deal directly with abortion rights, but the tangential issue that is happening in the case it is involves abortion. So I include it in this section. It very much harkens back to the first section where we were when we discussed freedom of speech. So I used it because it's current, and I say current, it being 7 years ago, but also because there's another line of cases that I don't do that isn't about abortion access as well, or abortion access, but about protesting around abortion clinics. And I figured doing the most recent case will give you a view into the window of what that case law sort of looks like. So this case comes out of the state of Massachusetts, where the Massachusetts legislature passed a law which instituted a 35-foot zone around abortion clinics in which leafleting, flyers, protesting, pamphleting couldn't happen. And their argument in this case was that this was a non-content speech restriction, which the state can engage in, only demonstrating that there exists a rational basis for the restriction. So this is what we would call, at least according to the state of Massachusetts, a time, place, or manner restriction. So not content-based, but based upon time, place, or manner. And so the question in this case is, does this restriction passed by the state of Massachusetts run afoul of the First Amendment through the 14th Amendment as applicable upon the states? And in a unanimous decision, the court says, yes, it really does. And the reason for that, the court says, is because while there's no question that the regulation is content neutral, because it doesn't just prohibit individuals protesting who are anti-abortion, it applies to all individuals who would be engaging in those activities within this zone. However, the zone includes a number of what we would consider traditional public forums for speech to be engaged in. Sidewalks, roads, any number of things that are traditional public forums. And by limiting them, you're cutting off access to the traditional means in which speech and debate takes place. This is the historical venue for speech and debate. And you're placing an undue burden on individuals' ability to engage in free speech in these bounds. And so even though the law in question is content neutral, it is cutting off the avenues of speech that had historically been the main avenue of speech. And therefore, the law in question is simply overbroad. It's not narrowly tailored. It goes far beyond the goals that the state of Massachusetts had in passing the law. And because of that, the law must be struck down in terms of it being a violation of the protesters' First Amendment rights. Now, there's a concurrence in this case, and it's Justice Scalia's concurrence. Justice Scalia often had a way of cutting to the core of the issues. Many times I don't agree with his writings, but in this case, his writing it's persuasive. And what he says is that we can talk about this being a content neutral restriction as much as we want, and that it would apply to anyone. But the only people that this bill is technically regulating are individuals who would be protesting abortion clinics. And so while on its face, one could argue that this law is content neutral, in application, in any sort of application, it's only applying to one group, and that's individuals who are protesting abortion. And therefore, the restriction is functionally a content-based restriction, and therefore it must rise to the strict scrutiny standard. In this very case, there's no question that the state was trying to regulate abortion protesters, and even if the law that they passed doesn't specifically textually target them. The intent of the law was to target them. And therefore, laws of this kind, which provide buffer zones around ideologically charged areas that might be content neutral facially, are really content-based restrictions. And that's not what the majority says, but I think that's a very persuasive argument, is that even though the law itself seemed to be facially content neutral, no one who was observing this case couldn't really shy away from the fact that the state of Massachusetts was attempting to regulate and was attempting to prevent abortion protesters from having access to individuals attempting to seek an abortion. Like, that was the intent of the law, despite how it was written. His concurrence agrees in the outcome of the case in the striking down the law, but his argument is that this particularized law and others like it are absolutely content-based restrictions and should have strict scrutiny applied. In this case, that doesn't happen, but it's a fairly persuasive argument, and one that, if cases like this were to arise again in the future, I would expect to, with the current court, gain a bit more traction.